Everyone, today we have with us Mr. Nipun Saxena. He is a practicing lawyer in the Supreme Court of India, and he's also worked on the Aadhaar case and is now also filed a review petition in the Supreme Court regarding the very Aadhaar matter. So today we'll be talking to him about the effect of the 5 judgment and how the judgment will flow towards a new direction into the regime of privacy and all in India. So let's begin.
So, sir, what could be the possible effects of this judgment, of the 9th judgment, and if you could dwell upon the PAN and Aadhaar linkage aspect of it. Also, we need to, the third aspect of my question is regarding the compromise of data. That's an issue that's been talked about in this judgment. So what are these 3 things, if you could dwell upon?
Alright, so we'll take the second issue first. There was a judgment that was pronounced in the matter of Binoy Biswan, where the question was with respect to the proviso to section 139AA of the Income Tax Act, right? Which essentially said that if a person does not link his PAN card with his Aadhaar card within the caption deadline, then he will be relegated to a position as if he had never applied for PAN card. And therefore, all the income tax returns that he would have filed from that day till this day would be considered a nullity and therefore expose him to criminal prosecution. So non-linking of Aadhaar with PAN card would have resulted in that situation. The judgment in Binoy Biswan started on a demurrer, saying that the larger issue of privacy being of constitutional right then would have to be decided by a larger bench strength in Justice Puttasswamy's case. So we are not touching upon this question as yet. The 9th judge bench does not make a reference to the question which was posed by Binoy Biswan. They said that let the constitution bench of 5 judges deal with it in the context of Aadhaar. Now the 5 judges bench did not deal with that question, in fact heavily relied on Binoy Biswan in a circuitous logic. So Binoy Biswan said refer it to the 9 judge referred it to 5 judge, but 5 judge did not consider Binoy Biswan. So, and in fact gave it a logic to say that PAN linking and Aadhaar linking is mandatory because Binoy Biswan says so, but Binoy Biswan does not say so. Therefore, that was one of the primary grounds of mounting a challenge. There is also another problem with it. There is a specific provision within Aadhaar Act in the definition clause itself, which is section 2K, which says that biometric information shall not include information pertaining to one's medical history or pertaining to one's income. Now, income tax return is in fact the information which is pertaining to one's income. Once you establish that, and the very definition clause itself precludes it, then you are in a situation where neither did Binoy Biswan nor did Justice Puttasswamy's 5 judge bench ever had the occasion to consider this statutory provision. You cannot bring an amendment to the Income Tax Act which basically goes against the definition clause of the Aadhaar Act itself. When the definition clause itself prohibits income statements or information pertaining to one's income ever being linked to Aadhaar in any manner whatsoever, then I believe it could not have been done. So it was simply impermissible. So that there's another aspect to it, which is that filing of income tax is neither a benefit nor a subsidy or a service. Now Aadhaar can be taken because the scheme of Aadhaar Act suggests that the government can ask a citizen to part with the biometric information provided the government is giving him either benefit, subsidy or service in return of that biometric information. That's the exchange, so to say, in terms of the scheme of the statute. But if filing of income tax does not fall within benefit, subsidy or services, then where does it fall? To my mind, it's a statutory mandate. It's a statutory compulsion. As a citizen, I am supposed to file my income tax because if I do not file my income tax, then I am exposed to criminal prosecution. Therefore, in my understanding, there is no need, even within the mandate of Aadhaar Act, to have forced me or compelled me to link my Aadhaar with PAN information. So I think that's one place where both, with utmost respect to both benches, they have not considered the same. Coming to your third point, which is with respect to the possible compromises I would say, compromises which have already been made to the privacy of individuals. Now we understand that the right to privacy judgment, which is the judgment authored by the 9 learned judges, have extrapolated various dimensions of facets of privacy, which include spatial privacy. I'm harping more on informational privacy, which is the consent of an individual to part with his personal information, which may amount to sensitive or personal data. Now, as we have been able to witness from the arguments that were made across the bar, we came to realize that in the year 2016 is the time when Aadhaar Act actually comes into force. Prior to that act coming into force, the UIDAI was established on 28th January 2009 itself. So from 2009 to 2016, information which is sensitive and personal in nature was being collected from all the citizens of this country. Dehorse any statutory protection which was afforded. Therefore, what happens is that UIDAI at that particular point of time did not even have the requisite informational or cyber infrastructure to store that data. And therefore, UIDAI entered into a series of contracts with private players who are based outside. Now, if you enter into an agreement with private players who are also called BSPs or biometric service providers. Now, these biometric service providers were companies which were essentially incorporated in different countries. Now, when they were incorporated in different countries, then they were subjected to the laws of their own countries. Say a server is based in Delaware, United States. I'm just throwing a city name. It will be obligated to mandatory disclosure requirements of its own laws. And therefore, from 2010 to 2016, most of the information was stored on servers which were based abroad, in the hands of private players. And therefore, to my mind, there was already a breach of the cherished right to privacy that is said. Now, what does the Act do in order to cure it or in order to legitimize a breach? It includes a savings clause and also incorporates a section 23 subclause 3 which authorizes UIDAI to enter into any contracts with private players. And then the savings clause says that any action which was undertaken by the UIDAI prior to the commencement of this Act shall be deemed to be valid and shall be deemed to have been done as if it was done under this Act, thereby affording what you call a retrospective protection to a constitutional breach. Now that, in my estimate, is completely impermissible, because you cannot have a retrospective protection of something which takes away your inherent right to privacy. So I think these are certain points which need to have been looked at by the benches that were considering the decision, and since they did not, that is one of the reasons that has compelled us to move the Honorable Court for a review. There is another very important point that was with respect to the fact that now once these servers are stored in foreign locations and they are subject matter to disclosure requirements of those countries, you do not know whether the information stored on that servers was already leaked or not. The Constitution Bench decision says that this may be a possibility, a futuristic probability, and therefore we direct UIDAI to take appropriate steps. This is according to Justice Sikri's opinion. The counter that comes to my mind is this: the date on which the Act comes into force, which is on 31st March 2016, merely 4 days thereafter, which is on the 1st of April 2016, the Press Information Bureau of India released a report saying 100 crore enrollments are already done. So if 100 crore individuals, I'm not using the word citizens because it includes both residents and non-residents, residents and citizens. So 100 crore individuals' data stood transferred as on that date. So to my mind, it's not a futuristic probability, it's in fact a concrete lapse of right to privacy which has been taken away of not less than at least 100 crore people. And therefore, this is not something that could be dealt with by UIDAI. The entire data had to be deleted, it had to be erased, but which was regrettably not done.
So, sir, the fire judgment also read down section 57 of the Aadhaar Act, which deals with which entities can or cannot use the data. So, what did the fire judgment say on that, and how will that unfold in the future course of things?
So, the Constitution bench understood and appreciated the arguments which were canvassed, which was to the effect that many body corporates, companies, telecom service providers, schools, colleges were asking individuals to part with their Aadhaar information. The first thing is that it is only the state that can ask for Aadhaar. In fact, I will go to the extent and say it's only UIDAI that can ask for Aadhaar. Any other entity is precluded unless, of course, there are certain provisions. In terms of the provision, they make an application and all that. But insofar as companies or private entities or body corporates are concerned, they have no business whatsoever to use your biometric information. And therefore, the Honorable Constitution Bench rightly read down the provision and omitted the words body corporate or any person. Therefore, Aadhaar can be used by any other entity which is government entity but not a body corporate or person. But which brings us to another sequitur. As on the date of passing of the judgment, information which was sensitive and personal data was already collected by most of these corporate entities. To my mind, if the Honorable Court were to hold, and which it has rightly held, that section 57 is to be read down and not include corporate or body corporate or companies, then there had to be a necessary direction, a consequential direction to delete all the data which was in their possession, and such direction was not in fact made. So that again gives us another ground to seek for that consequential direction, because the data till date is stored, processed and protected by those entities which are based on. So I think that's the gist of section 57.
So one of the major controversies that surrounded this Aadhaar Act since its inception was regarding its introduction as a money bill. So if you could dwell upon this issue and regarding the role of speaker and how this judgment particularly addresses these two important questions.
So what happened was that Mr. Jairam Ramesh immediately preferred a petition. As soon as the speaker decided in exercise of his powers under Article 110 of the Constitution to determine that this was in fact a money bill and not an ordinary bill. Now, if it's a money bill, it will never be introduced in Rajya Sabha. The fact of the matter is that this challenge was taken immediately to the Supreme Court. And the Supreme Court had clubbed this matter along with Justice Puttaswamy's matter, and they wanted to decide it together. Now, the Honorable Supreme Court, speaking through Justice Sikri, had, in the majority opinion, pointed out that at best, the decision of the Speaker cannot be called into question because it is a mere irregularity of procedure. We would say that this is not a mere irregularity of procedure, but you have bypassed an entire discussion, deliberation and passing of a bill as an act. The entire process which had to undergo in the Rajya Sabha has been thwarted. And therefore, to use the expression employed by Justice Chandrachud in his minority opinion, it's a constitutional fraud which was played. Now, in order to counter the minority opinion, the majority opinion heavily relied on Muhammad Siddiqui's case. And they quoted it verbatim. Many paragraphs were quoted. But what was not quoted from that judgment was paragraph 39, which clearly said that judicial review could have been a possibility if the objection to the power of the speaker, the discretion of the speaker was taken immediately there, not at a time when the act was passed. in that case, what happened was that the amending act was passed and it was too long in the day that they woke up and decided to challenge the discretion of the speaker. And that was a specific categorical finding which was there in the judgment, and that is where the entire case turned on its own head. Otherwise, to say that merely because there is a clause which says that no court shall call into question the decision of the speaker, will it prohibit exercise or judicial review by constitutional courts? The answer is a resounding no. Because there are bench strengths far superior in number, say Kilhoto, and followed by Rameshwar Prasad and so many other judgments. It's a consistent judicial trajectory of cases which says that merely because there is, say, a provision which bars a court from hearing the matter, that expression does not include a constitutional court exercising its power of judicial review. Because the power of judicial review is also envisioned and embedded in the Constitution itself. And therefore, one provision of the Constitution cannot go contrary to another provision of the Constitution. So you look at it from any angle, whether you want to employ principles of harmonious construction or you want to give primacy of one constitutional provision over another provision, the fact of the matter is clear, and it is right that the decision of the speaker is amenable to judicial review. Has that happened before? The answer is yes again. It has happened in cases of disqualification on the grounds of defection. Paragraph 7, if I am not mistaken, in 10th schedule also excludes and bars the courts from exercising their jurisdiction once the decision of the speaker has been made. But even in those cases, it has been held by the Supreme Court that nothing prohibits, prevents or precludes the constitutional courts from exercising their jurisdiction to carry out judicial review. And I think that is precisely where the majority opinion has run amok, in the sense that it has run contrary to the decisions that were passed by benches of a superior strength, and therefore they ought to have been bound under Article 141, but the same was not done, regrettably. So this is also one of the reasons why we would be challenging that.
So Nipun, so what are the major grounds that you have taken in your review petition that you recently filed before the Supreme Court?
So the major grounds are pertaining to the inclusion of Section 139AA and giving effect to 139AA. Another thing is the distinction between citizen and resident. See, because Aadhaar can only be given to any person who has resided in India for a period of not exceeding 182 days. But if I am a citizen and I am the one who is paying my taxes, then I think it is my brethren who are citizens who are entitled to it. Because it's not a question of state largesse. The question here is that the state's resources are also finite in number. And therefore, it is the citizens who ought to have first right to those resources, even assuming it's only for the grant of benefit subsidy services alone. Even there, the citizens stand on a higher footing than residents. Aadhaar, unfortunately, dissolves or dilutes that distinction between a citizen and a resident. There is no way today to find out who is a citizen and who is not a citizen, because by virtue of getting an Aadhaar card, most of the non-residents have been able to find many different IDs or say procure different ID cards. And today they stand on the same footing as a citizen, claiming for the same benefit subsidy services, which only a citizen could have claimed as a matter of right. So I think those are some of the grounds, in addition to the ones that I've already mentioned, that we would be pressing for consideration before the court.
Thank you so much, sir.